by decision dated August 17, 2001, respondent was suspended by this court for an additional period of 6 months, matter of Hogan, 286, Appellate Division, 2nd, 546. He now applies for reinstatement. Our examination of the papers submitted on this application indicates that respondent has complied with the provisions of the order of suspension and with this court's rules regarding the conduct of suspended attorneys. He has also complied with the requirements of this court's rule regarding reinstatement. Petitioner has advised that it does not oppose the application. The application is granted and respondent is reinstated to the practice of law effective immediately. Ordered that respondent's application is granted and he is reinstated to practice as an attorney and counselor at law in the state of New York effective immediately. On February 16, 2001, this court suspended respondent from practice for a period of 2 years, but stayed the suspension upon conditions that 1. Respondent not be the subject of any further disciplinary action, proceeding, or application by petitioner arising from his prospective conduct, and 2. Respondent submit to petitioner quarterly reports by a certified public accountant confirming that he is maintaining his escrow accounts and preserving client funds in accordance with applicable provisions of the attorney disciplinary rules. Matter of Madison. On March 12, 2002, petitioner issued a letter of admonition to respondent. Upon her plea of guilty to the crime of driving while intoxicated, defendant was sentenced to 5 years probation. In March 2001, defendant pleaded guilty to violating the terms of her probation by repeatedly failing to report for probation proceedings and by having consumed alcohol. She was sentenced to an indeterminate prison term of 1 to 3 years. Defendant appeals, challenging her sentence as unduly harsh and excessive. In light of defendant's demonstrated inability to abide by the conditions of probation, we are unpersuaded that the sentence imposed, which is within the permissible statutory range, was harsh and excessive. In satisfaction of an indictment which included a count of sodomy in the first degree, defendant entered a plea of guilty to the reduced charge of attempted sodomy in the first degree. He was sentenced in accordance with the plea bargain to a determinate prison term of 4 years with a 5-year period of post-release supervision. On this appeal, defendant contends that his plea allocution failed to establish all of the elements of the crime of attempted sodomy in the first degree and that the sentence was excessive. Neither argument has any merit. As a result of defendant's failure to move either to withdraw his plea or to vacate the judgment of conviction, he has not preserved his challenge to the factual sufficiency of the plea allocution. And in the absence of anything in defendant's recitation of the facts, which casts significant doubt on his guilt by negating an essential element of the crime, the narrow exception to the preservation rule is inapplicable. In any event, defendant's challenge to the validity of the plea has no merit. See, for example, People against Martinez. We are similarly unpersuaded by defendant's challenge to the severity of the sentence. Considering the leniency accorded defendant in permitting his plea to a reduced charge, and further considering the nature of the crime and the fact that the agreed-upon sentence was substantially less than the possible maximum for the reduced crime, we see neither an abuse of discretion in the sentence imposed, nor any extraordinary circumstances which would warrant modification of the sentence in the interest of justice. See People versus Annette, 262, Appellate Division 2nd, 670. In July 2000, petitioner An inmate in a state correctional facility filed a claim with respondent seeking reimbursement from the lawyer's fund for client protection of a legal fee paid to an attorney with whom he had consulted during the criminal prosecution that resulted in his incarceration. Upon denial of his claim and subsequent requests for reconsideration, petitioner commenced this CPLR Article 78 proceeding to review respondent's determination. The Supreme Court dismissed the petitioner's application and his appeal ensued. We affirm the record reveals that petitioner paid counsel a $750 retainer to review his case and provide an assessment as to the merit of the prosecution, which counsel did. Additionally, the record reflects that the Attorney Grievance Committee investigated a complaint filed by petitioner and concluded that there was no evidence that counsel had violated any disciplinary rules of the Code of Professional Responsibility. That evidence provided respondent with a rational basis to conclude that petitioner's complaint involved a fee dispute rather than a misappropriation or willful misapplication of client's money, and accordingly, the petition was properly dismissed.
That's pretty good. How fast was that?
130.
130?
Yep.